Reckoning point of the market value of the property. Compensation is determined as of the date of the filing of the complaint for eminent domain, but where the filing of the complaint occurs after the actual taking of the property and the owner would be given undue incremental advantages arising from the use to which the government devotes the property expropriated, just compensation is determined as of the date of taking. From the case of National Power Corporation versus Court of Appeal. So generally, compensation is determined as of the date of the filing of the complaint for eminent domain. Exception is when the filing occurs after the actual taking of the property. So ang compensation, ang reckoning period sa compensation is determined as of the date of taking. The case of Islaban versus De Honorio. The Supreme Court said that in the instance where the appropriating agency takes over the property prior to the expropriation suit, just compensation shall be determined as of the time of taking, not as of the time of the filing of the complaint for eminent domain. Thus, it was declared that the value of the property must be determined either as of the date of the taking or the filing of the complaint, whichever comes first. So, sa Islaban versus De Honorio, if first ang taking before of the expropriation suit, ang just compensation is determined from the time of taking, not as of the time of the filing of the complaint for eminent domain. Kinag-una man ang taking itself. It should be noted that the principal criterion in determining just compensation is the character of the land at the time of taking. In National Power Corporation versus Hinzon, the trial judge based his computation on the price of lots in the adjacent developed subdivisions, although the 5 parcels were agricultural but later reclassified as residential. The Supreme Court said that the trial judge had no valid basis for his computation. The tax declaration is only one of the factors to be used in determining the market value of the property for purposes of arriving at the amount to be paid by way of just compensation. When eminent domain is exercised by a local government unit, the amount to be paid for the expropriated property shall be determined by the proper court based on the fair market value at the time of the taking of the property. This was applied in, that's from Section 19 RA 7160. This was applied in City of Cebu versus Spouses de Damo, precisely because the expropriator was the City of Cebu, a local government unit, and the rules of court cannot prevail over RA 7160, a substantive law. In Nepomuceno versus City of Surigao, it was held that the value of the property shall be ascertained as of the date it was taken, because it is of that date, of that time, that the real measure of the owner's loss may be fairly adjudged. Entitlement of the owner to the interest. In Nepomuceno versus City of Surigao, it was held that once the value of the property is fixed by the court, the amount shall earn interest at the legal rate until full payment is effected. In National Power Corporation versus Angas, fixes the interest due the property owner at the rate of 6% per annum prescribed in Article 2209 of the Civil Code, and not the 12% per annum under the Central Bank Circular Number 416, because the latter applies to loans or forbearance of money, goods or credits, or judgments involving such loans or forbearance of money or goods or credits. The kind of interest involved here is by way of damages, hence Article 2209 of the Civil Code applies. So, ang entitlement to interest generally is 6% per annum as per Article 2209 of the New Civil Code. 12% is not applied because it applies mainly as interest to contracts of loan. So later may bauta sa exception. In expropriation cases, the court imposed an interest of 12% per annum on the just compensation due to the landowner. It must be stressed, however, that in these cases, imposition of interest was in the nature of damages for delay in payment. In effect, makes the obligation on the part of the government one of forbearance. It follows that the interest in the form of damages cannot be applied where there was prompt and valid payment of just compensation. Conversely, where there was delay in tendering a valid payment of the compensation, the imposition of interest is in order. In this case, the replacement of the trust account with cash or LBP bonds did not ipso facto cure the lack of compensation, for essentially the determination of this compensation was marred by the lack of due process. Thus, the compensation due Waikoko should bear 12% interest per annum from the time the LBP opened a trust account in his name up to the time the said account was actually converted to cash and LBP bonds. From the case of Waikoko versus Judge Caspilio, 2004. So, ang general rule in the entitlement of the owner to the interest, 6% per annum rajod as per civil code. Ang 12% per annum dili ma-apply kay interest na sa contract of loans, except when the imposition of interest was in the nature of damages for delay in payment. So, if late ang payment, ma-impose ang court of damages in the form of 12% per annum. So, take note, no award of damages when payment was prompt and valid, just compensation only when na ay delay in payment, mahimong 12% per annum. Who else may be entitled to just compensation? Entitlement to the payment of just compensation is not, however, limited to the owner, but includes all those who have lawful interest in the property to be condemned, including a mortgagee, a leasee, and a vendee in possession under an executory contract. But whereas in this case, the interveners had no longer legal interest in the property because at the time of the expropriation, their claim of ownership had already been resolved and put to rest, they are not entitled to the to be impleaded as parties to the payment of just compensation. Katong Dinesh nga case, Dinesh versus Court of Appeals. Title to the property. Title does not pass until after payment, except in agrarian reform. So, generally, ang title mapas after nanay payment, except in agrarian reform. Under resolution of motion for reconsideration in the case of Land Bank versus Court of Appeals. Thus, the owner of the land subject to expropriation may still dispose of the same before payment of just compensation. The case of Republic versus Salem Investment Corporation 2000. Taxes paid by the owner after the taking by the expropriator are reimbursed. The case of City of Manila versus Rojas. Right of landowner in case of non-payment of just compensation. As a rule, non-payment of just compensation in an expropriation proceeding does not entitle the private landowners to recover the possession of the expropriated lots, but only to demand payment of the fair market value. The case of Republic versus CA. The case of Reyes versus National Housing Authority 2003. However, in Republic of the Philippines versus Vicente Lim, the Supreme Court said that the facts of the case do not justify the application of the rule. In this case, the Republic was ordered to pay just compensation twice. First was in the expropriation proceedings, and second in the action for recovery of possession, but it never did. 57 years passed since the expropriation case was terminated, but the Republic never paid the owners. The court construed the Republic's failure to pay just compensation as a deliberate refusal on its part. Under such circumstances, the recovery of possession is in order. It was then held that where the government fails to pay just compensation within 5 years from the finality of the judgment in the expropriation proceedings, the owners concerned shall have the right to recover possession of their property.